Pleas. When it comes to plea deals, it's very much like how most people would be consumed with the thought that there are fixed options. Generally speaking, there's three common types of pleas. There's more types of pleas, but generally speaking, there are three common ones: guilty, non-guilty, and no contest. Meaning you're not saying you're guilty or that you are guilty. Sometimes they loosely refer to it if an attorney's doing it against you, they do null and prosecute, meaning they're not going to pursue it at all for whatever reason that might be vague. But that null and prosecute usually entails reservation of rights to bring their claims back up when they have sufficient evidence against you. They usually use it as a tactic to kind of get you to relax and waive your rights of looking into the case docket and then coming back and sneaking something in, and 5-6 years later you wonder, okay, I thought that case was dismissed. No, it wasn't dismissed. They temporarily put it to the side because of workload or maybe as a tactic and strategy. Plea deals exist in abundance, but the three common ones are guilty, non-guilty, and no contest. And your plea deal, as we've went over before, basically hands you to them. Now, if you think you have no other choice than to plead, regardless of whether you're offered one or you voluntarily do it, because you can do the same thing they do. You can put something to the side and come back once you're ready. Nonetheless, regardless of whether you've screwed up in the past or not, you can always withdraw those pleas, meaning they cannot be used against you, and it's simply based on due process. The whole concept of being presumed to be innocent until proven guilty. Part of it is scattered around within the rules of evidence. In this case, for the sake of uniformity, the Federal Rules of Evidence, Rule 410, plea discussion, and related statement. Prohibited uses in a civil or criminal case. Evidence of the following is not admissible. It's not admissible. Evidence, remember, rules of evidence is all about what proves the truth and what convinces whoever it is, whether it's the truth finder or the fact finder, to go, okay, this guy, you deserve to go down, or this guy, just leave him be. He's fine. None of this happened. So evidence of the following is not admissible against the defendant, meaning this section is specifically created to favor the defendant. Evidence of the following is not admissible against the defendant who made the plea, or participated in the plea discussion. A guilty plea that was later withdrawn. A nolo contendere plea. Contendere in Latin just means contest. A statement made during the proceeding on either of those pleas under Federal Rules of Criminal Procedure 11 or a comparable state procedure, or a statement made during plea discussion with an attorney for the prosecuting attorney if the discussion did not result in guilty plea or they resulted in later withdrawn guilty plea. Exceptions: the court may admit a statement described in Rule 410A3 or 4. Any procedures. There it is right there. By not directly telling you that your pleas, if you pled guilty, you can withdraw it. That's the principle of due process. Does some form of fascism function in the court one way or the other, whereby you have no say in it and they just do what they want? Yes, they do, but they cannot run away from the foundational principle of, I don't really like going into politics, but there are certain intents that were created when these court systems and the supposed government was established. They can't run away from those principles, and they use that to their benefit, and because that's what empowers them, and they have to keep it within these parliamentary procedures so that they can tap into it just in case, or their offsprings can put it to use. And that's why they privatize everything. into the British accreditation registry system and other orders and whatnot. But nonetheless, the bottom line here is if you've pled guilty in the past, you can always withdraw it because such evidence is not admissible against you. And if you plead no contest, it cannot be used against you. If you a later withdrawn guilty plea cannot be used against you. Sure, there are exceptions. So here are the exceptions. The first exception is specific to criminal proceedings dealing with perjury or false statement. That plea was made under oath and you had counsel present, meaning you made a well-informed decision. Again, that counsel does not have to be a British accreditation registry member. So the exception to you being able to withdraw your guilty plea are one, dealing with specifically perjury or false statement criminal issues, and you swore under oath and you had a well-informed decision. You made a well-informed decision. The second exception to not being able to withdraw your plea is in Rule 401. A3 and A4. It says test for relevant evidence. Evidence is relevant, meaning it's contrary to what we just read, whereby evidence cannot be used against you if you withdraw it. Evidence is relevant if it has any tendency to make a fact more or less probable than it would without the evidence. The fact is of consequence in determining the action, meaning if you had snitched on yourself and they're saying, hey, you did that, you did this, and you say, you know what, yes I did, and that video that's happening, that happened, and then later you're trying to say, well, you know what, I didn't do it. But they're gonna look at you and say, well, but you said in that video, which we have here, which is the evidence that you did do it. In fact, you can't really withdraw that. It creates a probable cause against yourself. You've created a probable cause for yourself, and the Constitution does in fact speak about probable cause. So in the case that your guilty plea creates an affirmative cause, a probable cause for them to say, all right, you are in fact guilty, then you will have a mildly difficult time withdrawing your plea. Although there are many loopholes to counter this Rule 401 exception to withdrawing guilty pleas, but it would in fact be a battle. So just a little of a helping hand, because one of the first things that they will offer you, part of the business plan and part of their private parliamentary procedure, which is usually not disclosed to people, which is usually in the form of manuals and stuff like that, is that they must approach you with a form of negotiation called guilty or non-guilty plea. Simple as that. They only give you those two options. But then when you bring up, no contest, they kind of go, oh, well, yeah, but it's better if you do this, and then they start hitting you with the years of, if you don't do this, you go to jail for this, fine this. They play on your emotions rather than looking at constitutional principles. But nonetheless, there you have it. There's your solution. If you fell into the trap of pleading guilty, there's a solution. And even if there's an exception that you effectively snitched on yourself, there are still solutions. Just keep that in mind.